Welcome to another episode of the Lawyer Society Legal Podcast. This is episode 31, and recently we have been getting a lot of attention, a lot of followers. Thank you for that. And if you are a new listener, do follow us on Spotify and also give us a rating because that will give me a bit more encouragement to continue this podcast. Okay, let us proceed to the main focus of this particular episode. Today we'll be talking about quashing of criminal investigation under the new CRPC, which is the BNSS of 2023. Now, as I have already described in some of my conversations, and also I have written an article about this in the September 2024 magazine, which will be published on Sunday, that is the 1st of September. So if you're interested, you can check out the magazine and you can also pre-order the same. Now, getting back to the topic, there are two different views with regard to limitation under the CRPC, and both these two views are regarding police report cases, not with regard to complaint, that is the magistrate complaint cases, private complaint cases. In police report cases, you have two views. One is the limitation ends when the complaint or information is being given to the police. The next view is that the limitation ends when the charge sheet is filed before the magistrate by the police. So we have two views, and we have different judgments backing these two views. One very recently pronounced by the Madras High Court in Kalyaperumal versus SP in the year 2024. You have two or three other judgments from the Madras High Court to back the other view. We also have various judgments from several other high courts for both the views, and you can find all these judgments in the article that I've written in the September magazine. So as I've already said, these two views prevail only under the CRPC. They don't have any role to play under the BNSS. This is because as per the explanation given to section 514 of the BNSS of 2023, the end point when it comes to police report cases is to be computed by taking into account the date of registration of FIR. So when the first information report is registered within limitation, there is no limitation bar. So there is no question of the time that is being taken for the filing of charge sheet. Having said that, now what will be the implication of this particular explanation that has been added to the chapter regarding limitation under the BNSS, which wasn't there in the CRPC? Usually we see the fact that a lot of criminal proceedings are quashed because of the fact that either the charge sheet was filed beyond the period of limitation, or the charge sheet has not been filed but the limitation has ended. So any given period, say the offence has a limitation of 1 year or 3 years, and the limitation has ended but still the charge sheet has not been filed, then the High Court might consider, when you file a 482 application, it might consider, given all the material and the nature of accusations, the offence might be quashed, that is the FIR might be quashed, or even the charge sheet might be quashed if the charge sheet has been filed beyond period of limitation. So you get the point, right? Now, as it stands today, you cannot claim quashing of FIR or charge sheet based on the date of filing of charge sheet, because it has been made clear that the limitation ends with the date of filing of FIR. So as long as the FIR has been filed within the period of limitation given for an offence, you cannot go claiming quash on such ground. Now, what other remedies does the accused have in case the police are investigating for years and years together? Because now you have an express leeway that is being given to the police, using which they can say they can keep investigating the offence, and they have no parameters to limit their time. This might be misused to a large extent. But however, you can still, I believe, refer to Article 21 and take the ground of there being a delay in investigation, nature of witnesses, nature of evidence. If, say, the accusation involves evidence that must be taken into custody, or eyewitnesses whose memory will be destroyed or damaged, with the passing of time. And in all such cases, the accused can still say, hey, look, this is an offense which is supported by an eyewitness, but the offense occurred 6 years ago. So how can you trust the witness if at all this matter reaches the trial court? In all such cases, you can still probably cite the delay as a reason, even if you're not able to refer to limitation per se. So this is the new issue that you have under the BNSS. That is, the police do not have any limitation guiding them or limiting them or protecting the accused persons. This, I think, must eventually lead to the High Courts or the Supreme Court laying down guidelines establishing how the police must investigate within a set timeline for certain offences, so on and so forth. And the state governments must bring in some sort of guidelines, police standing orders, and revise their police standing orders so as to include such new guidelines regarding filing of charge sheet within certain time. I hope you found this episode useful. Please do follow the Lawyer Society podcast on Spotify and give us a rating if you liked it. And also do comment your thoughts. If you want to subscribe to our Legal Bites, you can share your email address in the comment section below, or you can send your email address to the phone number listed in the comment section below and also the description box. Apart from that, if you are interested in reading a law magazine which I'm writing, you can subscribe to the Lawyer Society Digital Law Magazine by clicking on the link given in the description box below. It is very affordable, and I do a lot of legal research on the everyday cases that we come across. So I hope it will be useful to all of you. Thank you. Until next time.